are 3 case files. Well, case file number 1, training. Using content to train AI, even without displaying it, can be infringement. Thomson Reuters. Intent matters. Building direct competitors with someone else's content will face a little scrutiny, but think about it. Is there a competitive edge? Data is going to become even more rare as people start realizing that the real value of AI is in the data and your intent. So even though Ross Intelligence did not intend or even want to output anything, the training helps the output. That's how I read the court seeing it. The training still maybe doesn't give you exactly that, but it gives you something that's way smarter because of the value of the copyrighted IP from Westlaw. But if you're looking at it just like any business, follow the money trail. And if you follow the money trail in Thomson, it's really clear competitor buys data, even though it's legal, copyright still rules. Now, the New York Times is saying that their data was taken, and they can show a lot of short examples will, like Authors Guild v. Google, show us that those snippets don't really impact the total value involved here. And that is a really, really tough judgment, especially for some media company with the history and quality of the New York Times. So with all that data, what you're really playing for is 100 years of data from the New York Times that people have read that do become patterns. But if you could get exact articles out, if you could pull them out, you could actually argue it's in there. But is it real if you can only pull out a little piece of it? Does that prove copyright infringement? That's one that's going to be decided. 3 cases that tell one story. Thomson Reuters showed that even without visible output, training AI on copyright material is still infringement when building a direct competitor, that competitive angle. It was a special kind of startup move by Ross Intelligence. I sort of admire it. After being denied a license, he gets 25,000 bulk memos by going to a third party. It's nothing wrong with it. It's totally legal, and it's sort of surprising they caught him because most companies find out that their content's been taken way after it's already been put in AI. This was found out pretty quickly, and they had a strong case because it was already proven it was in there from the purchase and the records, so they didn't have to do the output dance. So output is not the only thing determinative of copyright, and that is massive for the AI industry. That is, input has been the holy grail, that we get it, it's copyrightable, but it gets transformed. All good, only on output. This is on input. See, the New York Times deals with partial outputs, snippets that mimic the definitive style of their journalism. Their claim that those articles are memory, not so true. Yes, AI can reconstruct patterns that come up again and again. But if all you're proving is these articles are in there, and there's snippets of them, and you're one of the most famous media organizations, will the snippets, if it's 20% as a general rule, will that be enough to prove damage? The Getty's image case provides the actual easiest, most visual evidence. There's Getty's logo right on top, even sometimes with the photographer's name right below it, with weird images that have distorted faces and glitches and hallucinations, which of course implies that their brand is associated with that. This is even better than scraping. When your brand gets associated with something negative, it's not good for you, but it's extremely good for you in court, in my opinion, because there's nothing stronger than brand in companies of Getty Images' size. That's the alleged taking, even more than the content, is the brand. And that could impact this at a level that is, I think, much higher than the other claims can be, but who knows? These economic realities, not abstract technical or legal principles, are going to define it because we don't have the law. The tech is brand new. So how else are we going to define it except for where the money trail goes? This is when AI becomes business. As much as it's easy to say to all you startups, keep going, if your startup is going to go, it's going to go. And if it goes because it bought data or this whole issue really impacts the bigger players that everyone's wrapping around, it would be thermonuclear. And I don't think it will be that. But how do we actually correct what is obviously a wrong? Listen to Geoffrey.
This AI picture, this AI painting, where is the real emotional contact in that? I mean, Wonder Bread is not bread.
The difference between surface copying and deep understanding matters. Not just in art, but in how we build AI. That's the money trail worth following. Because you may think it's easy to lose the creative element. There's a cost to that, and it's not just financial, it's human.